Hello again, everyone. Welcome to Washington Gun Law TV. I'm Washington Gun Law President William Kirk. Thanks for joining us. Hey, during the last legislative session, everyone got really spun up about magazine bans, preemption laws, pre-purchasing licensing requirements, FFL liability, and so on. And we spent all of our time focusing on that. Now, in addition to some of the bills that we spent all the time focusing on, there were additional bills kicking around, such as House Bill 1562, which dealt primarily with what would happen when a person went to restore their firearm rights after losing them. However, there was a lot more to it, and it's probably time to bring you all up to speed on that because the effective date of that law is going into effect here pretty soon. So today, let's spend a few minutes and get you all up to speed on all the new ways Washington State can take your guns starting next month. Okay, so what we are talking about now is House Bill 1562, passed by the Washington State Legislature, signed into law by Governor Inslee, has an effective date of July 23rd. It amends several portions of RCW 9.41, but predominantly the statute we're going to be spending time with today is RCW 9.41.040, a statute which unfortunately looks a lot like this, but it deals with all the ways you can lose your right to possess a firearm and how you can go about getting those rights back. It also talks about what happens if you are unfortunately found guilty of being in unlawful possession of a firearm, and I can assure all of you the penalties are not good. Now, in a nutshell, traditionally what we've been able to tell people here at Washington Gun Law is that if you get convicted of a felony or certain domestic violence offenses, felony or misdemeanor, you are going to lose your right to possess a firearm. If you're found not guilty by reason of insanity for those similar offenses, you will also lose your right to possess a firearm. And then if you are involuntarily committed into a mental institution, you will lose your right to possess a firearm. And those were the three ways under RCW 9.41.040 that a person could normally lose their Second Amendment rights. However, starting July 23rd, and this is an important date, there are all sorts of new ways in which you can lose your Second Amendment rights. Now, this is not lose your concealed pistol license, okay? This is not forfeit the firearm, okay? This is actually you lose your constitutional right to possess a firearm. It's as if you have been convicted of a felony. But when you see what's being added to the list, you're going to actually end up scratching your head, because the new offenses for which you now, if you are convicted, you will lose your Second Amendment rights include domestic violence under RCW 10.99.020. Now, I know you're all saying, well, that's already the case. Well, here's the thing. Yeah, if it's an assault for domestic violence, if it's a malicious mischief domestic violence, then yes, traditionally you're going to lose your Second Amendment rights. But there are other offenses. Any offense in Washington State Criminal Code could actually be designated as a domestic violence offense. What this now says is that anything that receives a domestic violence designation, so theft in the third degree, domestic violence, you would lose your Second Amendment rights. There are additional new disqualifiers, including stalking, cyber stalking, cyber harassment, excluding cyber harassment committed solely pursuant to the elements set forth in RCW 9A.90.1201A1. And by the way, for those of you, we will put links for all of those statutes down below. The one exception, of course, is if you're stalking a person by just putting an electronic tracking device on it and nothing more, apparently you're still safe enough to own a gun. There are more disqualifying offenses, and I want you to pay attention to the next few, because these are the ones that I typically see from people who watch this channel. These are the ones in which I see what are otherwise lawful and responsible gun owners sometimes being accused of these offenses. I am not saying committing these offenses, but they can be accused, and that creates a problem. And they include aiming or discharging a firearm in violation of RCW 9.41.230. Unlawful carrying, handling, or display of a firearm under RCW 9.41.270. So listen now, okay? There has never been any kind of a sanction for a 941.230 violation for unlawfully aiming or pointing a firearm at a person. I know it seems odd. Now there is a sanction, which is you lose your Second Amendment rights. Now on the 941-270 violation, unlawful display, there has always been a forfeiture of your CPL on a conviction for that for 1 year. But now if convicted, no, you lose your Second Amendment rights. And then there are a couple more that you need to be aware of. Animal cruelty in the second degree committed under 16.52.2071, or any prior offense as defined in RCW 4661-5055 subsection 14 if committed within 7 years of a conviction for any other prior offense under RCW 4661-5055. What is that? That, my friends, are the DUI laws. RCW 4661-5055 is the sentencing statute for DUI. So listen up. Listen up. This is important. If you have a prior offense, and a prior offense is any criminal charge that started as a DUI that either resulted in a DUI conviction, a deferred prosecution, or a plea to reckless driving, reckless endangerment, or negligent driving, and that prior offense occurred within 7 years of a new DUI allegation, if you are convicted of that second offense DUI, you are going to lose your Second Amendment rights. Now, this is with no finding that you have any sort of chemical dependency issues or mental health issues. A mere conviction for anything that qualifies as a second offense or higher DUI under RCW 4661-5055 will now disqualify you from your firearm rights. And then the final thing is a violation of any order that ordered you to forfeit your firearm rights. If you say, oh, to hell with that, I'm not going to obey that order, and you're found guilty of that, you will in fact lose your Second Amendment rights. That one probably should seem relatively obvious so long as the order was lawful in its inception. So these are all of the new ways that an otherwise lawful and responsible gun owner could end up losing their Second Amendment rights. Now listen, there are a lot of allegations that I have seen under these statutes: stalking, cyber harassment. You can imagine the bickering and the pissing contests that we see sometimes that lead to criminal charges. I'm not saying that people are convicted of this, but I am saying I see charges. And then clearly, you can imagine that I have dealt with multiple people who have used a firearm in a lawful self-defense situation, and either law enforcement or the prosecution disagreed with that and have charged them with 941-270 or 941-230 violations. These charges, unfortunately, are somewhat common in otherwise lawful self-defense situations. So this opens up a whole new Pandora's box of ways that you could lose your Second Amendment rights. Here's the other thing you need to be aware of. The soonest that you could petition to get your rights restored is probably 7 years from the date in which the case is resolved, because you're in all likelihood going to end up with at least 2 years of probation. You have to go 5 full years after satisfying the judgment in the case being closed. So you are now looking at not being able to lawfully arm yourself for about 7 years for a conviction of any one of these offenses. Okay, once again, it's House Bill 1562. We're going to put links for it all down below. The effective date is July 23rd. Now, this is important. We cannot apply this law ex post facto, which means if you are charged with an offense right now and post July 23rd, you will fall into this category. Do not worry, you do not fall into this category. It will be for any offense that is committed July 23rd or later. Once again, House Bill 1562, we'll put the links for it down below. If you have any other questions about this or anything else related to what's left of our Second Amendment rights, you guys should know how to get a hold of Washington Gun Law by now. But if you don't, that's okay, because that information is right down there in the description box. In the meantime, I do want all of you to remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation, how it applies to you in any instance that you may find yourself. Until next time, thanks for watching. Stay safe.